start the webinar now. Can I welcome all of you? And as the numbers go up, as we carry on, I welcome you all individually as well as collectively. My name is Sailesh Mehta, and Richard Bynon, my colleague. We should hopefully both be on screen. We are the participants in this webinar. This is the Red Line Chambers Health and Safety Update of 2022. Most of you will already know both of us. Can I briefly introduce Richard Bynon to you? Richard is a key member of the Red Line Chambers regulatory team. You will know him as a senior member of the bar. He prosecutes and defends a range of cases, but particularly regulatory cases at the very highest level. He advises the CPS, he defends companies and company directors, often fatality cases or cases involving the gravest injuries. Those that want to look up Richard in more detail, you'll be able to see on the Red Line Chambers website the number of key cases that he's been involved in. And of course, some of you may know me. My name is Sailesh Mehta. I'm also a member of the Red Line Chambers regulatory team, and I prosecute and defend in these cases. We've got quite a lot that we are going to have to pack in the next just under an hour, and you will see in a moment the number of potential slides that we have. And part of my job, apart from chipping in every now and then, is to make sure that Richard moves along as quickly as possible. What we're going to do, just in case we need to get through too many slides too quickly, is give you an assurance that at the end of this webinar, over the next day or so, you will be getting an email from us, which will have a copy of these slides, but more importantly, a copy of some detailed notes that attach to each of the slides with some links to relevant case law and some of the things that Richard in particular will be talking about. So rest assured that if we are going too quickly through a particular slide that may be of importance or interest to you, worry not, we will make sure that you get the full details over the next few days. Second thing before we start properly is to encourage everyone to ask us questions through the chat. And so I know that Joe Barrett, who's not on screen, who's dealing with the slides, will also make sure that everyone gets a chance to ask questions. And if possible, I will try to, with Richard's help, answer the questions as we're going through the slides. If inevitably we can't get through all of the questions, what we tend to do is to respond to each question after the webinar so that you receive an individual response from Richard Bynon and myself. And so without further ado, welcome again, and Richard, over to you.
Thank you very much, Sailesh. Good evening, everybody. Joe, could we have the first slide, or the next slide, please? This is going to be a canter through, in fairness, not just health and safety cases that have been reported, a canter through some of the legislation, and also, I hope helpfully, some other cases which aren't health and safety prosecutions, but deal with case management issues and the like. And towards the end of the presentation, there's a list of authorities, and you'll see the theme emerging of a concentration across the jurisdiction on the timing of plea indications and credit that's afforded. And it certainly plays a part in some of the health and safety reported authorities. But just to keep you, I suppose, up to date with the stats, recently published 6th of July, coincides with the 50th anniversary of the Robbins report that led, in fact, to the setting up of the HSE a year later. Next slide, Joe. And those are the figures. Construction, still the largest number of fatalities. closely followed by agriculture, forestry, and fishing. Even Stevens with manufacturing, really. And we can see from the latest stats, although you have to put COVID into the equation in terms of the information gathering. Falls from height, the most common, struck by moving vehicles, falling objects, and traps at the bottom there. Next slide, Joe. Straying a little into last year, Nestle, guarding an issue in that case, the after eight factory of the appellant company, cloth dragged into a roller on a conveyor belt. You can see the injuries on the slide, compound fractures, and so forth. Surgery, a £640,000 fine was upheld. It wasn't manifestly excessive. And as you'll know, a lot of these fines are geared on the turnover of the company. In this particular case, it was pretty high. But the interesting aspect to it was that, it's not set out in the slide, but it was remarked upon in the judgment that it wasn't a particularly timely plea, and the argument about credit fell away during arguments in the Court of Appeal. But that was one ground. Another ground argued was the failure by the judge to have regard to the fact that the company was being sentenced for a strict liability offence. Well, the Court of Appeal weren't having any of that. Unnecessary and undesirable. If circumstances were to exist where that was to be a difference, then that would be properly dealt with in the first stage of the guidelines, culpability. But they weren't interested in that argument at all. Next slide, Joe. Associated Waste Management Limited. Here, fall from height. Two people injured here, employee and an agency worker. So sections 2 and 3. Fell down a 4.2 meter gap, 2-3 meter gap in a gantry at the site. The gantry had been designed by a specialist company, and in the last 8 years, there hadn't been any indication of any issues at all with the platform, so it was argued. And a defence expert opined that a failure to ensure that the panels were accurately fitted and engineered within the gantry so as to prevent movement. The renewed application for leave to appeal was refused. Again, you can see there, guilty plea at the PTR. There was arguments about the amount of credit, unsuccessfully, obviously. But the issue was really whether the judge had erred in concluding that this was a case of high rather than medium culpability, in that a reputable, competent contractor had built and designed the gantry from where these two workers fell, and the company were entitled to believe that the bespoke system designed by Europe's leading manufacturer at such a high price it cost them would not have had such a basic defect. Well, they weren't able to convince the Court of Appeal about or the single judge, well, the court about that. Next slide, Joe, please. This is what they said. In terms of culpability, there was some modest force from the fact that this gantry was designed and installed by expert contractors, and that the risks ought to have been obvious to those contractors. However, agreeing with the judge, it remained incumbent on the applicant to put in place and carry out a proper system of inspection of the gantry on account of the obvious risk. The evidence in relation to such a system was somewhat hazy, and perhaps a warning to those of us who defend from time to time, and what you put in your bundles, because the court picked up if one page in the documents, I think it was page 48, represented the system in place, then the inference was there was a failure to implement it. So perhaps from the court's perspective anyway, a little bit of an own goal. But the court went on to say the clips had been missing over a considerable period of time, and there was an irresistible inference that a proper system of inspection would have picked it up. Given the number of occasions on which the gantry had suffered impact collision from diggers and other machinery, then the applicant must have known about it or should have known about it. And that led to the court refusing the renewed application. Next slide, Joe, please. W.H. Malcolm, £6.5 million fine here, failing to discharge a duty under section 3.1 and the management of health and safety at work regulations. A tragic case, if ever there was, really. W.H. Malcolm was the operator of Daventry International Rail Freight Terminal, which takes railway traffic from more or less everywhere, it seems. It also was a shunting yard, which posed their own dangers, but quite apart from dangers of the shunting yard, there were high-speed trains passing, falls and trip dangers from embankments and bridges and the like, all those trackside dangers. There was the added danger of the overhead line equipment, energized at 25,000 volts. The geography of this rail yard, shunting yard, was proximate to a bridleway and a bridge, which became known as Bridge D. The infrastructure offered inadequate protection on land, on the applicant's land, and tragically accessible. Next slide, Joe, please. In fact, what had happened was that a young lad, 6 young lads, in fact, it would seem, went to play football near the area, and the victim kicked the ball and found his way onto the track, onto the shunting yard on top of a train, came into contact with one of those overhead cables, and sadly died. The court held £6.5 million was appropriate to bring home to the directors and shareholders of the applicant company the need to comply with health and safety legislation. There was a serious failure to address the risks. It was a highly dangerous environment with no risk assessment at any time during the material period, and employees had raised concerns about that. There were identified previous incidents of trespass. The company did have a bit of a history. It was argued that that was of some vintage, There was a conviction 13 years before the instant offence, and there were or had been a number of enforcement notices of a different type. The court said that didn't render them irrelevant. What they did show, however their age and however different, was failures of safety management, and the judge was entitled to treat them as aggravating factors, explicitly recognizing as well, and in fairness to the applicant, notwithstanding those previous matters, the applicant had operated for many hours without incident. Another point argued was the effect of what the other children had seen happen to their friend. The fact that the impact of a death on others is not contained within the list of aggravating features set out in the guideline. That's what the defence contended. The court said that was wholly irrelevant. The guideline specifically stated that the list was non-exhaustive of aggravating features. Whether this factor can be said to aggravate the offence depends on the facts of each case. In this case, children were trespassing on site by reason of the applicant's failures. The number of them put at risk goes to the issue of harm within the guideline. However, the ongoing impact upon them of seeing their friend electrocuted is an entirely separate matter and capable of being an aggravating factor. This truly was a serious case of its kind, and all the guideline criteria for high culpability were present. Next slide, Joe, and Sailesh.
This is the case of CMBC Supply Limited. It's in fact known already as the Carlsberg case. Apologies for the blank slide. I'm afraid there have been difficulties technically at my end. I'm, as it happens, in Madrid in a hotel room, and there's been difficulty in sending the details. But by the time you get the slides, you will have the relevant details. This is a case worth reading, even though it's only a Crown Court authority, because it's Mr. Justice Picken at Birmingham Crown Court in June of this year, who gave a very careful, very detailed judgment that's worth reading, and we will make sure that you have the link to it. This case arises out of a fatal accident that occurred at the Carlsberg Brewery in Northampton in 2016. The background I can summarize in one or two sentences. It involves the freezing of number of materials using anhydrous ammonia, and as a result of that part of the process, the pipework and the flanges need regular updating. In this particular case, the relevant part of the mechanism needed to be isolated in a safe way, and it hadn't been isolated in the safe way. Hence, the prosecution under sections 2 and 3 for 3 offences, including the fatal accident and also a serious injury to another worker. Carlsberg pleaded guilty at the earliest possible opportunity. The key factor of interest that arose was whether Carlsberg should be treated as a large organization or a very large organization. There was much discussion about that. The prosecution, in fact, very fairly conceded or accepted that because of Carlsberg's turnover, it should not be treated for sentencing as a very large organization. Of course, that makes a potentially huge difference when it comes to sentencing. The judge at paragraph 50 said as follows, that for the Carlsberg to be treated as a very large organization, the guidelines, the health and safety guidelines, suggest that the turnover or equivalent should very greatly exceed the threshold for large organizations. The threshold for large organizations was £50 million turnover per year. Carlsberg's turnover was a little over or around twice that the maximum turnover figure for large organizations. So it was about £100 million a year. And so the question arose, is twice the 50 million turnover figure enough to tilt the organization into the very large organization threshold? The answer is no, as far as this charge is concerned, and that was accepted by the prosecution as well. However, within the large organization box, of course, the judge said that there was room for movement and a matter of discretion and judgment. And so no doubt the judge said that, or sentenced on the basis that Carlsberg was at the upper end of the large organization. The fine was in fact £3 million after the full credit for a plea. There was some discussion about whether the profit figure that Carlsberg reported, which was a fraction of their turnover, was relevant, and really whether the judge should significantly take that into account. In this case, the judge felt that that was not of sufficient relevance to make him change his £3 million final figure. I say all this in a little bit of a rush. I know that in our audience we have John Cooper, who was the solicitor for Carlsberg. And John, I know I probably made a hash of the summary, and I'd invite your comments. I know you and I have had a discussion about this case in advance of this webinar. So that's the Carlsberg case. It makes no new principle, but it's a useful read in any event. Next slide, please. This is the case of Brown, and this is another useful sentencing case. Again, apologies for the blank slide. You will have the full details in due course. This is a Court of Appeal case, Lord Justice Singh, and it relates to sentencing in fire offences. Those that know a little bit about fire offences will know that there are no guidelines. And therefore, the starting point, it is thought, should be the health and safety guidelines. And in fact, this case confirms that. Mr. Justice Singh says, confirmed that the case of Butt, and we'll give you the reference to it in due course, which also is a Court of Appeal authority, suggested that the starting point for fire offences of this sort should be the health and safety guidelines. But having said that that's the starting point, that is not the end point. And the rationale for that is that the health and safety guidelines cover a range of offences, some of which do not result in death or serious injury, or don't risk death or serious injury, whereas in almost every fire offence, the starting point is death or serious injury being risked. And therefore, the Sentencing Council decided not to include fire offences in the health and safety guidelines. But this authority confirms the proposition that the starting point should be the health and safety guidelines. This was a case involving a lady who owned a property which the fire brigade had serious concerns about. Number of breaches that were found when an inspection was made. So serious were the breaches that a prohibition notice was issued. Unfortunately, the owner of the premises, Jayne Brown, when contacted by the fire brigade, said that she had no intention of even visiting the premises, let alone doing anything to deal with the serious concerns the fire brigade had. They, of course, as you'd expect, sent an officer very quickly a second time round, no changes, a third time round, still no changes, hence the prosecution. She pleaded guilty, had a number of difficulties by way of mitigation in her background. What the sentencing judge did was to sentence her to a significant fine, around £100,000 fine, and also imposed a suspended sentence. On appeal to the Court of Appeal, it was suggested by the appellants that, firstly, that combination of suspended sentence and a significant financial penalty was unfair. The court gave short shrift to all appellant submissions. What the court said is there was ample authority for the proposition about the seriousness of fire offences, particularly of this sort. Secondly, one would look at the top end of the sentencing guidelines for health and safety offences, and therefore not wrong in principle at all to have suspended sentences mixed with a significant fine. Thirdly, even though at appeal there was an attempt to introduce new evidence to show that in fact the appellant did not have the £800,000 that the Crown Court was aware she had at her disposal. The court said, no, too late, you should have raised all of this at the mitigation in the Crown Court. The Crown Court judge was entitled to assume that the £800,000 was disposable income, and therefore 100k fine on top of the suspended sentence was not excessive. It reinforces, if one needed to reinforce, the proposition that at mitigation, during mitigation in the Crown Court, it's incumbent on the defendant and his or her team to put all of the mitigation, including financial mitigation, before the court. And if it's not all put, then the sentencing judge will be entitled to look at the gaps and say, I'm assuming that because there are gaps, that in fact the defendant has ample means to pay. So that's that case. Next slide, please.
Sailesh, you know quite a lot about water.
This is having prosecuted Thames Water on a number of occasions, and I think there may be more prosecutions in the pipeline, if you'll forgive the pun. This is, of course, the most famous water prosecution case in recent memory. £90 million fine. It was prosecuted by a colleague of Richard and mine in Chambers. Very well prosecuted, obviously, given this mammoth fine. And one of the key questions that arises is, can a fine, should a fine ever be big enough or so big that it is an existential threat to the defendant company? And the simple answer, Richard, seems to be yes. In extreme circumstances, not only is that envisaged by the courts, but in fact the sentencing guidelines for environmental offences envisage exactly that position, that there are some occasions, and this was one such occasion, 51 counts involving nearly 7,000 discharges, millions of cubic meters of effluent going into clean water. Over a long period of time. If ever there was a case of the most serious breaches of environmental law creating huge amounts of pollution, this was it. And the simple answer is, if £90 million is too much for the company, well, it will have to do the best it can. I hope that's a fair summary.
It is. Thank you, Sailesh. Next slide, Joe, please. Shareholders' responsibility of bringing it home, not a new concept, as we can see going back to 2011. Next slide, Joe. But perhaps of interest, on the 10th of June this year, the Law Commission published an options paper on corporate criminal liability. And when you get the slide, you can click on the hyperlink to it if you haven't read it already. Or have a copy of it. It is an interesting and detailed, I would say, analysis of corporate criminal liability, and be it the company or the directors and the attribution rule and the like. It's really well argued piece of work, but part of it is to do with this notion of kind of corporate death penalty. They stopped short, the Law Commission, on giving the court a power to seek dissolution. That was one of the options mooted. You know, can the court pass an order that would effectively put the company to death? And the Law Commission's view was, given that the courts already have the ability to impose a fine that would have the effect of putting a firm out of business in appropriate cases and given in other circumstances. There were some circumstances which a power to dissolve would be unworkable, and the example given was an NHS trust. The conclusion of the Law Commission on that particular section was the fact that fines were the only sanction available against a company or non-natural person was a severe limitation. But they did endorse the principles in the current sentencing guidelines relating to the imposition of financial penalties on corporate defendants. And so far as level of fine on and shareholder impact was concerned, they shared in the profits of the companies, and they shared in obviously the relevant cases with the company breaking the law. So there should be an incentive for them to ensure that boards have due regard to the need to comply. So, as I say, that document was issued or published in June this year, well worth a read. Next slide, Joe. Thank you. Guidelines generally, not a huge amount that affects the world of health and safety, but if at all, but there will be a link here for the Sentencing Council annual report. Shows how they go about their work and also their strategic objectives. 2021 to 26, the next 5 years, during which they are anticipating reviewing the totality guideline. And there will be a consultation coming out on a draft guideline in October 2022. Next slide. Legislation. Quite topical, I suppose, in one respect. The PPE amendment regulations, not much to write home about. There's revised HSE guidelines, largely remains the same, except that it's extended to who are described as LIMB workers, those who have a more casual employment relationship. They didn't come within the prior regulations, so they've been included in it. But as the guidance says, it's important to reflect that PPE is really the last resort to protect against risks to health and safety. Also, the PPE to those more casual workers has to be supplied free of charge. Next slide, Joe.
Richard, just on a slightly wider basis, looking at the background before we just move on to the next slide, and really a plug for Chambers. The COVID inquiry has started. A judicial member of our Chambers heads that inquiry, and we have one or two members of our Chambers who are involved in that inquiry. And no doubt it will be looking at this particular piece of legislation, but more importantly, protective equipment generally that was provided, particularly at the start of COVID in March 2020, to health workers.
And of course, which wasn't fit for purpose, or a lot of it. Next slide, the Fire Safety Act 2021.
I wish I could get away with saying that the reason for this slide being empty is really to focus attention upon my advocacy. The reality, of course, is the same as before. I'm in Madrid and I couldn't get these in the right format. But in a nutshell, just by way of background, we're at the 5th anniversary of Grenfell. We've had phase 1 of the Grenfell inquiry report. We're in phase 2 and we should be receiving a phase 2 report soon. The importance of that is that the government has pledged and has started, in fact, upon its pledge of putting in action as many parts of phase 1 recommendations as possible. And one aspect we find in the Fire Safety Act of 2021. We've had the Hackett report as well, Dame Hackett, and the government's also confirmed that it'll put as much of Hackett into practice and into legislation as possible. And so what's this space? This is an area which some people would say is esoteric and tiny, fire law and fire practice, but it's going to expand exponentially because of Grenfell, because there is a public clamour to ensure that Grenfell does not happen again. And there is, as a result of the public interest, of course, government is likely to fulfill its pledges. One of the things that you'll all be aware of is cladding on buildings, and you'll have seen videos of what happened to Grenfell and how fast the fire spread because of the cladding used. As a result of that, of course, there was a nationwide survey using various fire services to isolate and to decide which buildings needed immediate removal and replacement of cladding. Part of the problem with that is that it costs a lot of money. And so the owners of building were trying to not accept responsibility and make the tenants pay. And so a battle has raged over the last 3 years in particular between tenants and landlord. And of course, government has got sucked in. Various ministers in charge of this area have come and gone. I think a total of 4 in 4 years. Michael Gove was the last one, the Minister for Levelling Up. And he was the first minister that took charge of this public debate and made utterances which were very helpful to tenants, namely that the state or the owners of buildings in combination should really pay for the change or the removal and updating of cladding rather than the poor tenants. Unfortunately, that's not translated into law, particularly as the Minister for Levelling Up was levelled down during the recent happenings in the Conservative Party. And so, again, we'll have to watch this space. As far as this particular act is concerned, it makes changes to the fire safety order, which is the key bit of legislation that creates offences in this area. The big change that the Fire Safety Act brings into force relates to the structure, the external walls, and the flat entrance doors. All of them now fall within the fire safety order. Most of us who practice in this area knew that in any event, but there was some argument about whether flat front doors fell within the order or not. Now there is no doubt at all. The difficulty with that is that as a result of this act, those that have a duty to create risk assessments now need to make sure that their risk assessment deals with the structure, the external walls, and the entrance doors to the flats in the common areas. That means that they'll have to revisit each one of their risk assessment, and this is going to cost them, because to do a proper competent risk assessment, you've got to check the exterior walls, you've got to check the structures and all of the front doors of flats that lead to common areas. And if you don't do that in a competent way, then you could be prosecuted. The reason I can tell you that with some certainty is that I've just finished a 3-week prosecution in Portsmouth Crown Court. It was an unusual prosecution because it was one of the first times that a fire brigade has prosecuted a risk assessment company, a company that was a specialist in creating a risk assessment. And the allegation that the jury found to have been proved beyond reasonable doubt was that the risk assessment by this company in a particular high-rise block of flats or multiple occupancy block of flats was so poor that it did not meet the minimum standards. There are going to be more and more of such prosecutions, partly because of the Fire Safety Act 2021 amendment to the Fire Safety Order. Can we have the next slide, please?
Simply for interest and information, really, HSE published edition 3 of the Fire Safety and Construction this year. I can't remember now when it was, but it's quite recent, I think. There's a link there, or you can access it through the HSE site. It's managing fire risk during cladding and insulation removal. In guidance for inspectors is also published, supplementing HSG 168, and there are probably more, but certainly starting last week, or opening last week, 2 consultations on the new safety regime for occupied higher risk buildings, opened on the 20th of July until the 12th of October. Links there. Next slide, Joe. Building Safety Act, and for my own sanity and for yours, I hope I can canter through this pretty quickly. The Act linked to the slide, key vehicle for changing the building safety regime, received royal assent on the 28th of April this year. Important for all involved in planning, construction, property management, property dispute resolution, residential development, taxation, and health and safety. There is a staged introduction over a period of 18 months. Next slide, Joe.
This is, I should say, Richard, that this is an act that puts in place some of the Hackett report.
Yes.
Already there is consternation in the industry that the government seems to have backed off some of the key Hackett recommendations, having said that they would enact them. Yeah,
I mean, reading through the Act, I have to say there's a huge amount that is simply put down to the Secretary of State to issue regulations on, sort of. But anyway, so that's the timetable. Next slide, Joe. We have the only bit I think at the moment is in force is by the commencement transitional and saving regs 2022 came into force on the 28th of June, provisions that establish the health and safety executive as the building safety regulator, various amendments to the Health and Safety at Work Act, amendments and repeals to the Building Act, in particular, section 120D to H, relating to the regime regulating the higher risk buildings. Date for commencement of other provisions not yet available, made known, other than within the landscape. It hopefully within 18 months of the royal assent. Next slide, Joe. Look, there it is in all its glory. Next slide, Joe. And more of it in its own glory. Next slide, Joe. The definition for high-risk buildings, there was a difference between the construction phase and the in-occupation phase. That's being corrected by regulations that are going through that'll include not only the 18 meters, 7 stories, but also more than 2 residential properties. There was a consultation on the secondary legislation that will further define higher risk buildings. And that consultation finished on the 22nd of July. As you see, it's going to happen, 18 meters, 7 stories, and at least 2 residential units, which will cover care homes and hospitals, but not military premises or prisons. That, of course, there are 2 parts. There's the construction and design stage, and then there's the in-occupation stage. Next slide, Joe. The in-occupation stage is section 65 of the Act. And you can see the difference is set out there to read at your leisure. Next slide, please. Duty holders, just in passing, it'll be additional, but will be much the same way as, in fact, the CDMs are now. But oddly, they published, well, not oddly that they published, rather oddly that they unpublished them, but there were draft statutory instruments in relation to duty holders withdrawn on Monday with a link to further guidance, which says, amongst other things, duty holders such as the principal designer and principal contractor under the Act will be required to manage building safety risks with clear lines of responsibility during the design, construction and completion of all buildings. Well, nothing new there. Next slide, Joe. Role enforcement, again, updated guidance here on the 25th of July. HSE intends to apply proportionality, transparency, consistency, accountability, and they will publish their EPS in relation to this area, and targeting is clear, consistent, those consistently in breach. Next slide, Jill. Of perhaps more relevance to crime, I've set out on the next few slides what I believe are the principal, if not complete, criminal offences. I apologise if they're not all there, but it certainly would give you a flavour when you get the slides to see what offences are created. Next slide, Joe. And that is the amendment to the Building Act, as previously mentioned, now in force.
One of the interesting aspects of how the prosecutions will pan out in the future is the interaction between the health and safety executive in what it will consider is a relatively new area for it, and how that ties in with the local fire services who prosecute in areas that are similar to these, and whether they'll be working together, and the demarcation responsibility, because on the one hand, the HSC is a national body, on the other hand, the fire services are all local bodies, and therefore there'll have to be some sort of agreement between the chief fire officers and the HSC in demarcation, exactly who does what.
Yes, probably some sort of protocol or such as exists within work-related fatality cases, something along those lines. Next slide, Joe, please. Further offences set out there. Next slide. And some more summary offences, failing to comply with notice requirements set out there. Next slide, please, Joe. Next slide, Joe, please. Thanks. More offences. Next slide. And next. And this is what you were talking about earlier, Sailesh, the amendments brought into the fire safety order, which is the main piece of legislation concerning that. Next slide, Joe. Disclosure affects us all practicing in regulatory work within the Crown Court. Revised Attorney General's guidance, effective from the 25th of July. Large parts unchanged, apart from paragraph numbers, but some alterations to note. Next page. Third-party material, new paragraphs inserted, further prescribing the approach to be taken to disclosure held by third parties, principles of accessing third-party material, establishing a reasonable line of inquiry, establishing relevance and balancing rights. Of course, the CPIA is as applicable to the Health and Safety Executive and regulatory agencies as they, in fact, they are the police. Next slide. Thanks, Joe. Duty of engagement continues to be encouraged to better aid the understanding of the defence case and likely issues early on.
And Richard, this is a two-way street, and particularly amongst our audience, those that defend, those that are the most proactive at the earlier stages are the ones that can control the battleground better. Number of times one complains at court as counsel at the start of a case on lack of disclosure, and the response from the judge is, well, what did the defence do until today? And therefore early engagement is the order of the day, I suspect.
Yes, and in fact, the next slide we'll see. Thanks, Joe. Next. We'll see. It is emphasised that there must not be any speculative requests for prosecution disclosure under Section 8 of the CPIA. And if we, there's a section on redaction, what's proportionate, what's disproportionate. Next slide. And we see a good example of it in a different criminal jurisdiction. Judge stopped a case for abuse of process. It's not health and safety related, but the principle is an important one. Judge allowed himself to be influenced by irrelevant considerations, strength of the prosecution case, age of the allegations, and the fact that two of the defendants were unfit to plead. There was, in that case, reprehensible disclosure failures, but that was not enough to reach the level of grave misconduct that would undermine public confidence that was required for a Category 2 abuse of process application. I've set out the examples of what they were pretty awful, to be sure, but the judge was wrong in that case to stay the case on the basis of that material non-disclosure. And they gave this warning. Next slide, Joe. Requests for disclosure drawn too widely tend significantly to undermine the proper functioning of the disclosure process. Most particularly in the context of the present case, requests for investigators to review a complaint or other witness digitally stored communication should have a proper basis. There is no presumption that a complainant's mobile telephone or other devices should be inspected, retained, or downloaded. There has to be a properly identifiable foundation for the inquiry, not mere conjecture or speculation. So pretty strong observations there about requests that are unjustified. Next slide, Joe. Another example where it would appear the SFO didn't disclose communications it had with a private investigator who was working alongside the US authorities. Retrial wasn't in the interest of justice there. Next slide, Lally. Cross-examination. Judge entitled to limit, these are all matters that those of us that deal with health and safety cases come across as well. Defense indicated they needed 3 to 4 hours to cross-examine a victim in an attempted murder case. Husband, the wife was the victim. The judge allowed 90 minutes. Court of Appeal said nothing wrong with that. The issues were pretty straightforward, and there was no need for any longer time. Next slide. Another aspect of the case which is important was that there was a juror note which after they retired, well, there was a note from the juror to the effect that she was autistic and was worried about it. Proper inquiries of her were made, and she carried on as a juror. Court making this important observation, I think, the advantage of 12 people made up of citizens randomly selected are that they are inevitably people who come to a trial with different lived experiences and different abilities. This particular juror's autism is but one aspect of that. People with different mental and physical abilities and disabilities make up the society from which jurors are selected. And those differences are not a basis for excluding anyone, provided that a juror can be faithful to his or her oath, trying a defendant on the evidence.
Just as an aside, Richard, in the Bannon trial in America, one of the potential jurors said that he could be fair, but he believed that Bannon was guilty and had no defense at all. No surprise that he was asked to be recused. We've got very limited time. I hope our audience will forgive us for taking 1 or 2 more minutes extra.
Yes, if nothing else, to explain what's left of assistance. Next slide, Joe. Judicial interference. I prosecuted Mr. Musafa for health and safety offences. He was also prosecuted by the council for breach of an enforcement notice, and that relates to this case relates to that prosecution and not mine. We won the Newton hearing, but just to give you some idea of the difficulties faced by defense counsel, who successfully argued that the judge had entered the arena. He did so repeatedly, and the appeal was allowed. Next slide. We should record that with 1 or 2 possible exceptions, the judge was always courteous. We are conscious that reading a transcript does not enable us to hear the tone, speed, or delivery of what's recorded. The transcript does not demonstrate overt hectoring or bullying of a witness at any point, although the judge's questioning was sustained and very extensive. The criticism that is made of the judge can be supported by a broad analysis of the scale of the judge's interventions during the appellant's evidence. Bearing in mind that the appellant had a mental health diagnosis. During the continuation of his examination in chief on the 1st of August 2019, 257 questions were asked of the appellant, of which approximately 116 were asked by the judge. During cross-examination, approximately 327 questions were asked of the appellant, of which 110 were put by the judge. The court said these figures themselves are startling, but they only tell part of the story. After the defendant had given evidence, he called a witness who was not cross-examined by the Crown, but was by the judge. Next slide, please, Joe. Next slide, Joe. Oh, that's the end of it. I see the time. That is a list of the cases really where, as well as the ones we've referred to, involve the importance of the timing of the plea in assorted cases. For example, where there's a basis of plea or where there's an alternative offence that's later pleaded. But the courts are pretty resilient. You have to get it in as quickly as possible.
From the defence point of view, Richard, I suppose the critical point is get instructions very early and put in a plea at the magistrate's court level.
Absolutely crucial.
Yeah, and if not, if there's a good reason not to, then keep a proper record of it by writing to the prosecution, writing to the court, explaining why it is impossible to give proper advice to the defendant, the company or the director usually.
And unless there are really good reasons for applying any of the criteria in section F of the guilty plea guideline, you know, you've got to get your indication of plea at an earlier stage, or at least caveat it on paper, but get it in as soon as possible.
Richard, I know there was much more that we could have discussed. So, for example, there's a paper on advising possible change in charging companies and company directors, and that is something that's well worth a read, because it is likely that in fact there will be legislative changes in strict liability type offences, or in the case of Prest, the Supreme Court authority, which seemed to, on one view at least, give companies and company directors far more protection than it seems that they are entitled to. That's just one of the many areas that we still have left to cover.
Yes, of course.
That's about it.
The link is set out in the slides.
Absolutely. Can I thank you all for staying the course? Apologies we've not been able to finish. It's an impossible task to do a proper roundup in the space of time that we have, but very grateful to you, Richard, for taking us, cantering, sometimes galloping through it. Thank you very much to Joe for dealing with the slides in the way that you have, and thank you to our audience. You will be hearing from us, so to speak, with full details of this slide with the links. Thank you.